law firm, and one that was also specialized in investor state arbitration, defending states. One of the hallmark cases, because we're both nationals from the same country, is the case where they defended Electrocaribe. That was a difficult case, and they managed to actually defend it successfully. So that's the type of caliber that we have on the table. She is also a lawyer from my home university in Colombia. And there's so many reasons why we should be proud of her, or I am proud of her. In any event, I won't embarrass her anymore. But it's wonderful to have you here, and do keep track of the various panels. And this is part of the experiment that we're doing in trying to bring to you practical sessions. So Maria Carolina, take it away.
Thank you, Jose Antonio. Thank you, Jose Antonio, for that very kind introduction. And thank you to Alan Overy and the Washington Arbitration Week for the invitation. I'll start by introducing our panel. As Jose Antonio said, we have very experienced people in the panel. To my left is Ricardo Chirinos. He's a special consultant at Covington. He specializes in international, commercial, and investment arbitration, as well as public international law. And he has successfully represented clients prosecuting high claims in arbitral proceedings in English and in Spanish, in ICSID, ICSID Additional Facility, ICC, and the UNCITRAL rules. Next to him is Liz Snodgrass. She's a partner at 3 Crowns here in the Washington, D.C. office. She has 25 years of experience as an advocate and an advisor in international arbitration matters. She focuses on upstream energy, power, and the mining sectors. And she has particular expertise handling disputes involving states and state entities, including investment treaty cases, fiscal disputes under long-term contracts, and disputes that implicate both contract and treaty implications. Next to her is Nicolas Cordova. He's an associate at Freshfields, based also in Washington, D.C. Nicolas has acted in international commercial and investor state arbitrations as well, under ICSID, UNCITRAL, ICC, and the LCIA rules. And he has an experience across a variety of industries, including mining, oil and gas, energy, and telecommunications. And final but not least, it's Alexander Meniel. He's a partner at Cartier Meniel Schneller in Paris. He specializes in international arbitration and corporate litigation, and he has acted as counsel in commercial and investment arbitration proceedings, also under ICC, ICSID, UNCITRAL, and SEC rules, involving complex corporate disputes under corporate law, commercial law, and construction law. So to summarize, we have people with a lot of experience working across a variety of industries. And from those perspectives, today we will be discussing, as Jose Antonio said, the written phase of the arbitration proceeding. What to take into account when you're preparing the pleadings, what tips you can get from these very experienced practitioners, what strategic decisions need to be taken in the process, and what are some of the challenges that we face as advocates when preparing these pleadings. And with that, we'll start with Liz and Ricardo. Why are the written pleadings important in the arbitral proceeding? Can you go first?
I'm not sure I'm connected to Zoom, so I'm keeping one eye on the screen. Yes, it looks like I am. Sorry, bear with me. Join. So I would say that the written pleadings aren't just important, they really are essential in a case of any complexity whatsoever. I can't even imagine doing an arbitration without written pleadings. That they provide the parties and their counsel with an opportunity to present their case comprehensively, logically, systematically, and to feature the evidence and arguments and authority that support their their case. Because they're exchanged before the parties convene in an oral hearing, it gives the tribunal an opportunity to engage with the evidence and the arguments in advance, which increases the focus and efficiency of the hearing process, right? If everybody's across the range of issues, then the hearing can be focused on those issues that the tribunal finds most challenging or that the parties want to spend most attention on. And of course, the parties are then able to really engage with one another completely in an efficient process. I think the other thing that I just draw out, and then I'll hand over to Ricardo to pick up more on this, is what a written pleading gives you, of course, is not only the opportunity to set out your arguments, facts, and law, but it gives you a chance to set the stage, orient the tribunal to the story that you want to be telling, which is something that can be hard to do quickly in an opening submission, but you can start to lay the thematic groundwork. Is this a David and Goliath case? Is this a case that turns on a technical point, and the tribunal is going to need to be quite rigorous? You can start to use language and the framing of the arguments that you're putting forward to sort of characterize the dispute, characterize what's important, tell your story, orient yourself as the David and Goliath, if that's the narrative you're advancing. And those kind of pieces of mental furniture, those impressions that a tribunal gets very early in a case, can be really hard to dislodge. So if you don't get control of a narrative about the facts or the law, or at least try to do that, set out your stall on the narrative early in the case, it can be really, it's like pushing a stone uphill, a very heavy stone uphill, to change a perception that has settled. So it's a really important opportunity to start to introduce your client and their behavior and their position in the most favorable light. I'll stop there.
Well, I absolutely agree with you, Liz, and all of those points. I'll add a few more and perhaps comment on some of the ones that you've mentioned already. Pleadings are really the opportunity for the parties to make a first impression on the tribunal and be able to develop their case, their arguments, and persuade the tribunal of the strengths of their case and of the weaknesses of the adversary's case. So in that sense, it's essential to be able to give the tribunal that opportunity to create their initial views on the case and educate the tribunal on what this case is about. Why should I win? Why should my adversary lose? You really want to have the tribunal come to the hearing with some preliminary views as to what is this case about and who gets to win. And you do that by articulating your arguments and framing your arguments in your briefs. Ideally, you want them to be predisposed to favor you at the hearing. And as Liz said, it's very important to do so and to do it artfully at the pleadings, because once you've created an image in the mind of the tribunal as to what the case is about and who gets to win, and the tribunal has already some initial preliminary quote unquote views on the case, it's really hard for them to change them dramatically at the hearing. So through the pleadings, through the briefs, this is really the opportunity that you have to build the confidence of the tribunal and sort of start winning the case from the beginning. They also allow you, and in my own experience, it's a benefit for the parties as well, because once you put your case in writing, it allows you to think about your case more carefully. Once you think you have a case and you draft a notice of dispute and even a request for arbitration, you know the generalities of the case, but it's really when you get to the actual substantive pleadings, when you get to the memorial, sometimes when you uncover a few things that perhaps you didn't know before. And the ability to put things in writing allows you to understand your case better and understand your opponent's case better. So it's a good way to articulate your arguments in a clear way, to marshal the facts and develop the facts with precision and detail. And obviously you can tweak and polish your drafts as much as you want. So it's also a good opportunity to present a work product to the tribunal that has been very well thought. You have prepared several drafts, you have polished it, and now this draft, this product that you're presenting to the tribunal really reflects what you want to say after several rounds of revision. This This is an advantage of having written submissions versus a purely oral procedure. I would also say that briefs are convenient, and they're convenient because they give the arbitrators the ability to read at their own pace. They can, read chunks of a memorial and go back to them when they want, and read them more than once if they want to refresh their memory later on in time. And related to this, they are not also convenient, but they last in time. They are there forever in a way. Once you write something, the arguments will be written there, and you can reference them and go back to those memorials and quote those memorials, without limit during the proceedings. And it's good in a way, because when your opponent makes a silly argument, then you can go back to that silly argument in their memorial and throw it in their face. And if they have to depart from it, or if they have to correct something that they had said that was not correct, then you're affecting their credibility before the tribunal. It obviously applies both ways, so you have to be very careful as to what you do and what you put in writing. But we're all, the idea is that you have a good chance to review your work and present a very polished work product for the tribunal. So I'll leave it there, but I think I've given you enough reasons why the pleadings are an advantage.
And I think that's an excellent introduction. And we'll start from here on, going step by step on the different pleadings that happen throughout the procedure. And the very first pleading that we have is the request for arbitration. So, Nicolas, what is your process when drafting the RFA versus the memorial? Talking about this first impression that Ricardo was mentioning, what is the difference between the RFA and the memorial, and how do you go about it?
Thank you. Thank you, Maria Carolina, and thank you everyone for being here. Thank you, Jose Antonio, for the introductions. Let me go back one step. So rather than just going directly to the difference between one and the other, I have kind of identified 5 big but permanent features of RFAs, whether commercial or investor state, with one caveat to the commercial ones, which I'll come in a minute. And allow me to begin by saying your RFA is kind of your case theory. You never get to a case, you never file an RFA just to see what happens next, just to see if you do have a case coming forward or not. Bearing any discussions on potential limitation issues, you do draft your RFA because you already know the case theory, you already know kind of the 4 pillars of your table for anything going forward. And that being said, the RFA then becomes more of a formal document. The RFA is intended by all purposes to be a jurisdictional document, right? It is a document, or it is the document that lasts the longer in and of itself. It stands by itself the longest in any case. You do have some time differences between memorial, counter-memorial, reply, rejoinder, and whether you have bifurcated cases. But the document that's going to stand there alone for the longest is the RFA. So you do want to have 5 things kind of correct straight away. One is the parties. It sounds obvious, but you do need to identify who the parties are correctly from the outset. Most of the jurisdictional objections kind of coming from a res persona, a ratione persona argument will be focused on how you present the parties in the RFA. The second point is, what is your applicable instrument? Is it a contract? Is it a VIT? Is it an FTA? And you then start kind of trickling down through the various issues that each of those might present. It defines your remedies, it defines your rights, it defines your venue, It defines any time limits that you need to be careful or conscious about. And it also defines kind of the scope of the arbitration going forward. And it is linked to the third point, which is the issues at dispute. The RFA is not intended for you to present your positive case 100% right in. Sometimes, or most of the times, you do have cases that evolve throughout the arbitration, so you don't yet know the full scope of what might be in dispute. You may or may not have the entire set of documents that will support your arbitration, but you will definitely not have the entire set of evidence that you will need to present a memorial. You only start working on the witness statements and the expert reports a bit later, but we'll come to that in a minute. But you do need to present the issues at dispute, at least to provide some sense or guidance to the potential arbitrators as to what is that you're disputing, if you allow me the kind of the circle back of the argument. You do want to say, look, the measures at dispute are these, or these is the action that was taken by the counterparty that affected my rights in such or another way that brings us here. You will have additional time in later pleadings to perfect that argument, to fully support it, but you do want to give a sense of, look, this is what we're here for. The fourth point is you do need to present a confined set of documents to support those first 3 points, right? You do need a confined set of documents to prove who the parties are. You do need a confined set of documents to prove what the applicable instrument is. And you do need a confined set of documents to prove the issues at dispute. And when I say confined, is you do need to be careful about what you present in the outset. Why? Because RFAs are typically, in my experience, written with a time limitation in mind. You try to get the RFA kind of to toll the limitation period, whatever that period may be. And you then, after that, start the process of fully collecting the evidence that you will need in support of your case. Very rarely you do have a client and a case that will provide you with ample kind of scope to delve into documents, potential witnesses, experts, everything before the filing of the RFA. That typically happens after you have commenced the case. So you do want to have kind of those primary documents identified, but you do not want to, let's say, present more than you need at that point in time. And the fifth point is only relevant for commercial cases, which is you do need to pick your arbitrator and you do need to pick your seat. And that is a very demanding strategic task that you do have to embark on a very early stage. It only happens in commercial cases. In investor state cases, you pick them in a later stage. But you do need to make that determination with the RFA. And that will set the tone for the other party's appointment of his or her own arbitrator, because there might be conflicts involved, potential issues regarding languages. So if you have a case, let's say, in which most of the documents are in Spanish, most of the witnesses are in Spanish, but you picked from the outset an arbitrator that only speaks English or French, then you know from the outset that translations are going to be, let's say, an issue that you'll have to sort out. So all of that is designed and defined in the RFA, and it kind of sets the tone for the memorial, which comes next. And without prejudicing Alex, who's gonna delve a bit more on the memorial and counter memorial, the primary difference that I've seen between RFAs and memorials is how much do you hammer the facts, right? The legal strategy, as I was saying, is kind of already there. You already know what your case theory is when you file your RFA, but you may not know or may not have access to the full amount of documents and to the full amount of people that will help to prove your case. We will discuss a bit later kind of how you structure that. But for me, the primary difference is facts. Jurisdiction, literally, it's very similar. You kind of just develop it a bit further than what you have done in the RFA. But as long as your RFA is sufficiently robust to prove that the parties, the issues, and the time is good, you shouldn't be that worried at the memorial phase. The legal strategy won't change that much. You may want to add a couple of cases. You may have some time to review recent decisions, but most of your legal analysis has already been done, especially because you never file an RFA without drafting anything before. You usually have memos that you go to a client. You usually have a notice of dispute or a notice of intent in investment cases. So that portion is kind of already done. You only elaborate a bit more on that. And damages, well, we'll come to damages in a minute, but that's kind of a beast of its own. Facts is by far what you kind of focus the most when preparing a memorial. That is the key difference between an RFA and a fully fledged memorial. But I'll let others comment on that.
I do have one follow-up question for you, Nicolas, before we go turn to Alexander. And you mentioned it a little bit, but do you strategically decide to make the RFA more lean in terms of the facts before you have all the time to learn everything when you're preparing your memorial, or do you strategically choose to put everything in front of the tribunal with the RFA?
In my experience, I have chosen the former. So it's always preferable to have a linear but sufficiently robust document that you can file and passes all the jurisdictional tests, Article 25 of Exit Convention, or whatever, Rule 33 of the ICC rules. It doesn't harm if you present a lean but sufficiently robust RFA. Whereas if you go full-fledged and then a negative document arises, or the other party presents an issue that you didn't have kind of a full understanding of, it may be harder to backtrack from that. As Ricardo and Liz were saying, the documents are there, quote unquote, for the eternity, right? So you can always, you will have at least 2 additional chances to put forward additional arguments, additional facts. And if you do that from the outset, from the RFA, kind of that's it. Both parties may decide to obviate the point and say, well, it doesn't really matter now. But I typically, we've typically prefer the linear drafts to then kind of build them up in the later stages.
Can I just offer a comment about when you might think about a more full request for arbitration? Sometimes we've done that when you're really trying to get the other side's attention and sort of drive them to really confront the strength of the case against them and maybe come to the table and engage in dialogue. So probably not going to be effective in an investment treaty case because it often takes a lot longer for reality to set in those cases. But sometimes when you think if we could just really fire a shot across the bows, show our hand, show the strength of the evidence that we have, it can, the idea is that it might generate a discussion around settlement. Sometimes it works, sometimes it doesn't, but it has all the risks that you indicated of tying your hands a little bit more about the narrative that you're then going to develop in the case.
Yeah, and that's always true in commercial settings in which not always you're required to notify the other party before you file an RFA, right? Because in investment cases, you typically have a predefined time, a predefined setting to have those discussions. So you already kind of know whether settlements are possible or not.
And just one point, I think the point that you're making, Liz, is funny. I've had this in a case very recently where we knew that there wasn't going to be a huge amount of factual debate. We were confident in exactly in our hand. And what we did is we put out a really fleshed out request for arbitration, and we suggested that there only be 1 round, 2 rounds of submissions. And this is our first round of submission. And if you want to do an answer to the request of arbitration, and then you want us to do a fully fleshed first memorial, then you'll have to assume the cost because we're ready. This case is ready for us. I think that puts an enhanced pressure as well about how confident you are. And also the message that you're conveying to the tribunal, which is we're not going to be hiding away. We're not going to be playing games about getting more, more time, more evidence and doing document production, all of this. We're ready. We have it on, it's on the record. Let's go. I think that adds to the pressure, especially I think it's true in commercial cases, less perhaps so in investment, but yeah.
Thanks. So Alexander, you've been put in charge of drafting the first full written submission. What do you do first? What is your method?
There was 2 parts to your question, Maya Carolina. There was so you've been put in charge of drafting, then what do you do first? So I think in my teenage years as an associate, I would crack up a beer and go out, and then knowing that my social life would be miserable for the next couple of months, as I have matured, I've decided to take a different approach. Now I would obviously print out a calendar on Outlook, put it on a A3 piece of paper, and I would, I would try to figure out how we're going to work, because this is going to be a race against time. I think everyone who's litigated cases know that however prepared you are, you never have completely enough time to do all that is required. And so the way that I approach now is as a construction project. There's a critical path to getting your memorial in at the right time. And there's a way of securing that all the resources that you will need, or the subcontracting that you will need to secure is going to be there on time. I'm not speaking loud enough. Do I need to? No, so my point is, I think it's really about setting out the time. I think if you're very proficient, you've probably started doing that at the request of arbitration. So you've already started thinking about your case and started thinking about all the evidence that you didn't have at the time of the request for arbitration, or that you chose not to introduce at this time because you didn't think it was absolutely relevant to surcharge the briefing initially. But when it comes to the full written submission, as Nicola said, you have to hammer out the facts. And that means that you need to make sure that you have all of them, and you need to make sure that they're going to be laid out correctly. And that can take a huge amount of time. First, you have to locate where are these facts? Where are these usually? I mean, where are the documents? Is it going to be documentary evidence? Is it going to be witness evidence? Do we know where the documents are? Do we know how we can extract them? Do we know how we can treat them? Do we know if they need to be translated? And then we need to be reviewed and selected and properly prepared for filing. That in and of itself is a huge amount of project. If you've got documents situated in another country to which you have no longer access, that can be a huge amount of trouble. The same goes for your witnesses. Perhaps you're representing companies. Some of these employees are no longer with the company. Perhaps they're in foreign countries. You need to obviously secure how you're going to be approaching them, how you're going to be interviewing them, asking if they actually want to agree to perhaps appear in this arbitration. All of this takes a huge amount of time, because depending on the results that you're going to get, and sometimes you don't have all of it. I mean, if you're lucky, you've done a lot of that preparation before, but sometimes you're still running against the clock to make sure that you have all the documents for that 31st submission. And so you need to start planning. You need to go back in the clock and know when is the first brief that you're going to send to your clients, what do you need to do that? And that goes also with the expert evidence that you're going to be securing, because a lot of if you've got a big quantum analysis or you've got technical experts, they're going to need to have facts as well. So you're going to need to have all these facts, not only for your brief, but for their analysis. And that analysis is then going to come to a certain result, which you will then use, perhaps discuss with them, and then integrate into your own brief. So I think that the key point I want to stress first is really planning. I think it's just about planning and making sure that that you've delegated with a pretty strict planning to all the members of your team, the tasks that they need to be conducting to make sure that at each of these different milestones, you're ready, you can just check off the box and that your brief is moving forward for fighting on D-Day.
And on that point, Liz, as we all know, my experience, preparing the written submissions is a massive undertaking. It requires the work of several people, different teams. So how do you go along with that, and how do you marry the facts to the rest of the case, especially when you have different teams working on the different issues?
Yeah, well, first I'm going to issue a caveat. I'm about to describe an idealized process, which any of you in the room who have ever worked with me or who currently work with me will know is not necessarily how it always happens. So there's lots of tips and tricks about how to make it easier. I can't say we do this every time. I think your metaphor of a construction project is exactly right. The metaphor I like to use is when the brief comes together with different chunks written by different people, it's kind of like the assembled Frankenstein, right? You've got this creature, you're not quite sure if it's going to walk or move or take over the world, but you're trying to weld it together and then get it into a sort of seamless thing that speaks with one voice. There's some things that you can do to set yourself up for success before anybody really picks up a pen to be drafting. So I'll share those ideas. First of all, if you can, keep your team as small as humanly possible. Right? Sometimes that's not possible because people have other commitments or have specific expertise that needs to be sort of parachuted into certain parts of the brief. The smaller your drafting team, and indeed the smaller your team in general, the closer to everyone's fingertips the relevant knowledge is, and obviously the fewer voices and styles and all of that you're trying to integrate when you get a document all in one place. With respect to style, if you know that there are things that the ultimate audience, either the tribunal, the partner, the client, or all of the above, like or don't like in structure or drafting, get those ground rules agreed with your team and whoever's holding the pen right from the outset. Agree a style guide if you can. Redefine terms, so you're not having somebody spend an entire day just fixing all of those inconsistencies that creep in. So think about those things early in the process. Also, try not to divvy up drafting responsibility so that somebody who knows all of the facts is not writing the part of the brief that depends on those facts. Right? So try to be coherent in the way you allocate drafting responsibility. And then this really is, I think, the tip for how do you get a product that is as good as it can be when it's lying there on the table, having been bolted all together. If you can do this, if you actually write a real outline before anybody starts writing, debate the outline, agree it, argue about it, figure out how you're going to do it, and then actually write to the outline. And I'm just going to take those steps in turn. So what do I mean by a real outline? Well, the real outline is not a table of contents. If you get an outline that is just, first we're going to talk about jurisdiction, then we're going to talk about law, we're going to talk about the expropriation claim first, and then that's not an outline. That's a table of contents. An outline is one that says, all right, we're claiming there's been expropriation here, and here's the legal standard, here are the cases we're going to refer to, or just shorthand, this is the theory, this is it's indirect expropriation case, here are the key factual propositions that need to be made good to support that, and this is the order in which we're going to deal with these issues, and this is the evidence on which we're going to rely. If you can get all of that written out in an outline for each of the issues that you're needing to deal with before anybody picks up the pen, then you can agree, where's the detail going, where is this point going, does this evidence match up to this claim or to the other claim? And so, not just to take a series of headings, but a really detailed, not a paragraph level outline necessarily, although if there's a really tricky point that everybody's got opinions about, a paragraph level outline can be helpful. Debate the outline, get everybody's buy-in. If your client is the kind of client who cares about that sort of thing, get them involved with the process. Certainly get the senior members of the team to actually stop and think about it more than 48 hours before the brief is filed, because if you don't, they'll have a brilliant idea, or at least ideas, because their partner will be deemed a brilliant idea and have to be implemented 72 hours, 48 hours before the brief is filed. So get that, pinned down as much as you can, and then write to the outline. I would so much rather get a kind of slightly mechanical draft that doesn't jump off the page with beautiful rhetorical flourishes, but does the work that we said we needed to do in setting out the argument. That's much easier to work with and sort of jazz up than a beautifully written, beautifully wrought prose. It doesn't hang together, doesn't follow the structure, doesn't deal with the evidence in the way we need to deal with it. So, yes, it's great if you can write beautifully, much better if you can write plainly and following the structure that you agreed. And then the other thing, that the only way to really survive it is really try to, the work plan sort of schedule, construction schedule that you identified, really try to stick to that. Because then if you have built in enough time, when you start writing up a section of the brief, or somebody on your team starts writing up a section, they realize it just won't write, which happens all the time, right? You think you've got the argument, and then you actually start looking at the quotes you were planning to rely on from the cases, and you realize, Houston, we have a problem, right? You've actually got time then to go back around the table with the team and say, we're going to need to change that. What change does that drive in the evidence that we're developing? And and you can kind of stay one step ahead, or at least try to stay one step ahead of the chaos. And then obviously, to keep the fact evidence, my tendency in briefs is to set out the fact evidence in a factual background section pretty comprehensively, and then to be relatively brief and cross-referring to that section in the back of the brief. There's no magic in that. That's just how I've always done it. There have been some cases where we've divided things up a little bit differently, and you have sort of facts more interwoven issue by issue. It kind of depends on the size and the shape of the case. But what you don't want is that fact narrative to be developed in isolation, either in isolation of what the witnesses are actually going to say or what the documents actually say, or in isolation of what actually is the case for the document. So you need either the same people doing it and keep their brain switched on, notwithstanding the demands of work, or you need really good communication. And obviously the outline is a great way to ensure somebody can zoom out and go, does this forest, actually look like a forest, or do we just have, corn growing somewhere and tulips elsewhere? So that's it. Outline, and try to stick to the outline.
This takes us to the next point perfectly. So once you have done all the due diligence that Nicolas and Alexander were talking about, you have gathered as much of the evidence as you can. You have done the witness interviews. Ricardo, what is your process of writing the factual section, which is clearly an essential portion of the brief? Do you just do it chronologically? Do you choose to do it differently depending on the case?
Well, to start drafting, you need to do a lot of preparation. I think Liz has described a great deal of the preparation that goes into writing a memorial, in particular a draft section. But the first thing is obviously, organize the documents that you have and get them. To the extent you don't have the full set of documents that you need from the client, make sure that you get at least the basic documents and read them carefully. Spend some time reading them to understand, you already know what your case is about, but now you need to know the details of the case. So the first thing I do, and I encourage everyone doing, when you're drafting the fact section of a memorial, is read carefully. You will learn more about the case after reading the documents. You will identify portions of those documents that you want to quote, beautiful gems and documents that really support one of the arguments that you're making. That you will only find if you spend enough time reading those documents. And sometimes after you read them once, the document will not really show you all of the beauty of that document. You need to read it more than once to squeeze all the juice from the document. So read and read and read again the documents, so you know exactly what they say and how you can use them, or how can the other side attack you if you use that document, right? Then you will try to organize the information, and you try to organize the documents ideally thematically, but also chronologically. It's helpful to have a timeline, at least a rough chronology of what came first, what came after, what happened, what letter was sent. How did, in an investment case, how did the government react to this letter that you sent? Did something say something after this law was enacted? You want to you want to ask some questions, but also you want to try to see, what is the sequence of the events. And I think a timeline, a chronology, make your process. You can go back to it if you need it. You can complete it. It's not a work product. I typically don't like creating work product that doesn't go into what we need to deliver. But sometimes if the cases are complex, if there is a voluminous record, lots of documents, a lot of little things that happen, a lot of back and forth and correspondence that you need to know about, a timeline, a chronology is helpful. So once you have a good idea, already you've done that, you've read, you have a good chronology, you know the who, the what, the why, and the when of your case. That's when, talking about a fact section, that's when I am ready to prepare an outline. And an outline, outlines can be done at different stages, and they can take different forms. There's the skeleton outline, the table of contents outline that Liz was referring to. Then you will want to, once you've done this first read of the documents, you will want to do a 2.0 version of that has a little some content. You lay out, what your arguments are, what the legal standard is that you need to meet, what the elements are, what evidence are you planning to use, and then how you're going to demonstrate that you meet all the thresholds and all the elements that the legal standard requires. So that's the point where I would say it's a good moment to have a good first robust outline that can allow you to continue drafting the brief properly. And obviously at that stage, the outline is a good place or a good device for you to understand and put in, in some form in writing, why is it that I win? And what is it that the other side loses? And similarly, it's a good moment to know exactly what are the weaknesses of your own case and also the weaknesses of your adversary's case. It's good to know your case, but it's probably better to know your adversary's case, because then you know how you will be attacked and how you can respond to that. And maybe you know that you will need to preempt some arguments, so you will put yourself in a better position to receive the party's attack, the other side's attack, with respect to that point. And essentially, the outline allows you to identify the building blocks of your case, and always keep in mind those building blocks as you draft. For me, drafting is, as the outline is essential aspect. Always stick to your outline. Well, always stick to your outline and to the building blocks that are reflected in the outline. As you read and as you draft, there is a ton of information that you will receive and that you have to digest. Your job is to make the memorial a pleasant experience to read for the tribunal. If you clutter your memorial with facts and useless information, you will confuse the tribunal. It's not going to be helpful. You will not enjoy the process either. So the idea is for you to digest all of that information and always remember, what is it that I need to prove my case? What is really essential for the arbitrators to know? And by knowing that, you will start identifying as you go, oh, this is a colorful fact, but do I really need it? Or does this need to go above the line, or this is really a footnote point? You must start choosing how you're going to present the information to the tribunal. And again, it's a process. You don't do it in one go. This requires several drafts. And ultimately, after a number of revisions and input from different members of the team, then you have the beautiful work product that you want to have. But ideally, when you draft, then you will identify gaps in the evidence. You will do it in the outline, but also as you draft, you say, well, it'll be great if this witness actually said this or explained that, and it'll be great if I have a quote from the expert that I can add to my brief to explain this very complicated process that if I explain it myself, I'm probably not going to do it in the best way. I'm probably going to confuse the tribunal. It's better to take something from the expert that I can put there, maybe even a graphic that I can add to the memorial that explains this very technical process easier. So that's really how I do it. And again, it's not something that you do in one go. It requires lots of input, requires a lot of revisions, but practice makes the expert. And I think, we all have to embrace the process of drafting of something that, you plan things in a way, but then it all happens in a way that is slightly different, but you have to be flexible and be able to react to the challenges that you will confront. Maybe you will not find and you will not have all the information that you want, but that's part of the process, and we all need to be ready to attack when we have to.
And Nicolas, within this process, how do you deal with bad facts? Do you address them in your written pleadings? Do you choose to ignore them and hope that nobody will ever find them? Usually never happens, but
yeah, you never ignore them. You deal with bad facts as they come, and you have one of two options. Either there is some explanation or recharacterization of the facts that you can input in your positive case, and this is only for the memorial, right? If a bad fact comes with a counter memorial, then it becomes an argument rather than a bad fact that you need to deal with. But in the memorial, if you're reviewing something and you say, look, these 5 letters are wonderful to my case, but there's one attachment to one of these letters that is crappy, then I cannot omit it. I cannot say, well, the annex doesn't exist, but can I explain it somehow? Can I provide the tribunal and the other party with a soundful, colorful explanation of why that is there? And that's one option, but it depends. It's very fact specific, right? And the other one is, well, there's no way that I can reasonably explain this without a kind of auto-sabotaging my case, but I need to acknowledge that it exists. So you start playing with the above the line, below the line, cross-referencing, try to put it in such a way that you are disclosing the fact, but you are saying, look, in my case, this is not as relevant as you might think, and you just wait to see whether the other party or the tribunal eventually makes an issue out of that and picks it up and starts debating it, and then perhaps you will need a different strategy, try to come up with a different document. And by come up, I mean doing a different research of your database, trying to get to explain the document through a witness, perhaps, that you didn't thought of before. If it does become an issue, right? My point would be, you do need to acknowledge bad facts. You cannot omit bad facts, but you don't necessarily need to engage with all the bad facts in the same way.
And Alexander, does this process that we have been describing differ in any way when you're writing the legal and the quantum section?
I think obviously the underlying principles are the same to building any section on any legal brief. I think obviously that you have specific circumstances which differ when you're writing a legal section as to when you're writing purely the factual section, or when you're drafting the quantum section. So if we go now to the legal section, I would differentiate very much the legal side to the quantum side, which I think is again a monster of its own. For the legal side, this is where we're the most comfortable. This is this is supposed to be our expertise. Obviously, we always seek, the legal opinions of esteemed professors of law, but we're supposed to be understanding what they're saying, which is very different to what's happening in the quantum or in the technical expert evidence, where we are sometimes, well, it's difficult for us with figures and numbers and all of that. But when it comes to the way I think about the legal section is, I think it's different between a commercial case and an investment claim. In an investment claim, you should know quite easily what is the legal substantive provision on which you're relying to bring that claim. If you haven't figured that out, you shouldn't probably be fighting that case. For commercial cases, it can be a lot more muddy, because it can be relying on a very specific, narrow jurisprudential ground. So it's a little bit more complicated. But for an investment case, the way you're going to be dividing it, the way I've traditionally done it, is it needs to be the more clear as possible for the arbitral tribunal. So I would divide traditionally, you've got legal section, and I would divide on what claims you're putting before the tribunal for adjudication. And in that, each of these sections, you want it to be as clear as possible for the tribunal. So this needs to be very well delineated. And inside of each of these sections, you traditionally at some point, you're going to have to hash out the very dry legal principles. And that's going to have to be put somewhere. And this is where you do it. And then you apply that dry law to the facts that you've been talking about for hundreds of pages just before. Now, I think the trick, and it's always very difficult, is how much law do you put and how much do you rehash the facts when you're applying that law to the facts. I've traditionally found that this kind of varies substantially between the audience that you have as an arbitral tribunal. If you're in front of very, very senior, esteemed arbitrators, professors of laws, people who've been on countless tribunals in an investment case, obviously you're going to be putting a lot of principles, but you don't want to give them a law lesson. They've been sitting on most of the panels of the arbitral awards that you're going to be citing. I don't think you need to be telling them exactly what they've written. They probably know it better than you do. Doesn't mean that you shouldn't cite them, but there's a certain degree of deference in the way you're going to be presenting that case to them. In a commercial case, and I'm talking here about, for example, in ICC arbitrations, the odds are you may sometimes be called upon to sit as a tribunal in instances where you're applying a law that you have very little knowledge about. For myself, I'm right now sitting in an arbitration applying Swedish law. I don't have a Swedish legal background, but I'm very happy, and I'm, the geeky side of me is very happy that the parties in the council are substantiating very thoughtfully Swedish law. If this had been a French law experience, which is, I'm qualified in France, I wouldn't want to have a legal lesson in French law as much as I would need to in Swedish law, for example. So I think this goes back to what we were saying before. You're serving a dish, and make sure you're serving the dish to the right customer, right? You don't want to upset him by putting things that are unnecessary for him to understand and to come to the conclusion that he needs to come to. And so that goes back to what Ricardo was saying, is like, what do you need to do to demonstrate and to win this case? So I think that's kind of the point. When it comes to the quantum section, which usually comes at the end, I think here you really very much need to rely. This needs to be prepared very thoroughly with your experts, because you need to be preparing it with them. And this goes back to what you're saying about planning. You need to make sure that you understand what you're drafting, and you need to make sure that you've collaborated with them all along the preparation of their own expert report, because you can't just receive a report 2 weeks before filing and expect this to be plugged in without you understanding what the heck is going on and what's a DCF and what's these methods of evaluations. It's not going to happen. You're never going to be able to write a compelling argument if you don't understand what you're writing. You need to understand every word of what you're writing, and I think that's fundamental. It's very difficult for quantum, because obviously in the legal profession, the one thing that we don't do is numbers, and we don't have any accounting lessons. We don't do any financial forensic on any of that. So you learn by doing, but you obviously need to learn fast. And the best way to do it is to challenge. There's never a dumb question. These guys are getting paid by your client to answer your questions. They're pretty happy to do it. So when you're doing interview sessions with your quantum experts, you need to ask every question, anything. Obviously, you can Google some of the terms that you don't understand, and investopia, but you obviously need to be making these questions, because you're going to have to digest this to make sure that it's somewhat understandable and comprehensive for the arbitral tribunal. So yeah, and one last point, which I think is important, is I've always found that there's usually quite a discrepancy between the first interview that you have with a quantum expert, where they're valuing your case quite highly, and the first report that you receive, where somewhat the claims have been lowered, diminished, and they're not as comfortable with half of the facts that they said you're on. Obviously, they're selling a business, so they're very attractive initially. I think it's very important. This goes back to what Nicola was saying. You can't hide away bad facts, and you can't hide away bad claims as well. If your financial claim isn't as robust as you thought it were, if you're in the first round of pleadings, make sure you're diminishing it. It's not an issue if you've claimed a lot of money in your request for arbitration, but you're somewhat having a more shy approach, I think it's better to do it as the first memorial, fully fleshed memorial comes, than waiting until the hearing to say, well, yes, sorry, it's only a tenth of what we were claiming for. I think this will show a more serious approach, a more earnest approach towards the arbitral tribunal, something, which obviously will give more confidence and trust to the tribunal.
So, Liz, how do you integrate the witnesses and the witness statements into the process of developing your arguments? Do you take into account the legal backgrounds of the arbitrators? What strategic decisions do you make?
Well, the most important strategic decision is whether you actually need a witness. And the more I've done this, the longer I've done this, the more I have loved cases where I really don't need a witness. Witnesses, I mean, obviously can be essential depending on the facts you need to prove. They can be essential to humanize or embody particular equitable themes or whatever you're trying to develop. But witnesses are a massive wild card. I have never seen a witness win a case, but I can't say I've never seen a witness lose a case. So my starting point with witnesses is, do I really need them? And I think, 20 years ago, I would have thought, well, yeah, but of course, right? It's your claim, witness statements, expert. We need the whole package. And I think it's important to really be selective. So that dictates a process where you're obviously engaging with people at the client who might be witnesses early in the process to understand what happened, what's their take on it, where are the documents, who else knows about it. And you need to be careful in those interactions that if you are going to end up coming back to one of those people as a witness, you haven't muddied the waters with them, either by interviewing them in the group or by telling them what you think they remember in a way that leads to unreliable evidence. So you need to be careful in your interactions with people who may be witnesses. But then you really need to do what you said, really study the documents, understand what picture the documentary evidence presents, because that is not only going to be more compelling to the tribunal, it's also more likely to be accurate based on everything we now know about the fallibility of human recollection, right? So you need to be able to, in the nicest possible way, confront any witness with what the documents actually say and how that might differ from what they thought they remembered about how it all went down 12 years ago. And then you need to get quite rigorous, I think, about evaluating the evidence that you have, evaluating the factual propositions that you need to establish, and really ask yourself the hard question, do we really need a witness here? Obviously, if you're, alleging an oral variation of a written contract, you have to have a witness, right? But if you do it with documents, it's infinitely safer to do that. So if you get that outline or your kind of order of proof in mind, and you think, well, I can cover 90% of this with a witness, with documents, then keep the scope of the witness evidence extremely narrow, and you'll have done those initial interviews to understand who's likely to be in the frame to cover up those issues, and then you come back to them, with the narrow points that you need to give evidence on. So that's how I would approach it. Given that approach, I probably don't think as hard as I should about the legal sort of culture of the arbitrators that we're appearing before, because I'm trying to de-emphasize witness evidence anyway. So it's not a matter of thinking, well, I'm meeting with this for a common law tribunal, and I'm more reluctant about it with a civil law tribunal. Key advocacy decision then is, do you actually need a witness? And if you do you need more than one? Super dangerous, but do you need more than one on a particular issue that's very important? If the event's the key meeting, and how do you navigate multiple witnesses? And then the points you were making about dealing with bad facts. Sometimes you really do need a witness to draw the sting on a bad document, to recontextualize a bad document. But otherwise, you don't need a witness to tell the tribunal what documents it can read for itself say. Right? The witness is only going to say, yeah, there's a meeting where I noted in my notes that they said everything was fine, and that's what the document says. You don't need a witness to do that. I don't know. In my humble opinion.
One comment on the witness in this: when you have those initial discussions and you talk to the client and the people involved in the project or the transaction that the case is about, you may identify some potential witnesses, and some of them will actually end up being witnesses because you make the decision that you need them. But others that you've initially chosen not to have as witnesses, one will be great sources of information for you. So you will still have to treat them as witnesses in a way, because you will be going to them with questions every now and then to clarify issues or get more documents, or can you find if there was a letter in response to this other letter, or this other letter is referenced in this document, but I don't have it, do you have it? So in one way, you have to keep them as sources of information. And the fact that you don't use them at first doesn't mean that in rebuttal, you will not need to use them. It all depends on what comes after. You receive, say you didn't file that witness statement with your memorial, you're waiting for the other side to reply in their counter memorial, and depending on what they say, you say, well, actually now I need to respond to this argument with this, a statement from this guy that initially I didn't think I was going to need, but now I do. So be flexible and keep your potential witnesses with you, and tell them about the need for potential activity from them in the case later on.
Does that thinking process vary when you're dealing with experts, Nicolas? Of course, we will always be using damages experts, as Alexander said, we don't deal with numbers. But do you usually have other types of experts, legal experts? I've seen cases in where parties have decided to add an expert on investment arbitration cases, an expert on international investment law, which is usually a bit strange because the tribunal is an expert on the matter. We are alleged to be experts on the matter. So how do you go about it?
So yeah, well, thank you for making the distinction between valuation and other types of experts, because yeah, valuation is something that you just have to deal with. But with those others, that's where it becomes more interesting, because you usually have those other witnesses, those other experts, sorry, as a source of additional evidence for your facts, right? So you do want to prove how the local law, for instance, worked in a particular matter, or how a specific technical point from an industry perspective worked. So you bring in mining experts, which will then work along with the valuation experts on some issues, or oil and gas experts, or electricity transmission experts that can explain how when you connect one generator to another, it gets the electricity. And they will typically speak to the facts, but they can also speak to your legal theory. They can also and often speak to your evaluation section. I have seen once the international legal experts coming into play in a case in which we needed someone to comment on the specific treaty provisions. So more than a kind of generalist in international law, he was brought in because of his particular expertise on that instrument that was applicable to the case. Other than that, I have not seen international legal experts. Local legal experts are more of the general rule, but you do need to be very careful, because that would immediately send a signal to the tribunal that the local legal issues at stake are not as clear as you kind of said they were, or wish they were. It's very tricky to work with them, in the sense that, I mean, they are also lawyers, and more often than not, they may not be 100% convinced of your legal theory from an international perspective, let's say. And I'll be speaking here of investment treaty cases, because in commercial cases, well, you can bring them in just as support of your legal section rather than your facts. So that convincing process of, look, this is our theory from an international standpoint, this is what we need to prove from a local standpoint, which we need to present as facts, not as legal. We will be presenting this as how it actually works. That becomes it's a very interesting relation that you start generating with them. Also, the type of documents that you use in support, right? Because their evidence is typically what you would use as a legal authority, right? So it's judgments, a doctrine, opinions of specific bodies, and reviewing that evidence for them as well is painstaking, because it's very rare that you get, I don't know, a judgment from yesterday that says, we've accounted for all the judgments on this specific matter, on this specific issue, and this is, as of today, how an issue has been decided or determined. So you do need a very, to engage in a very kind of questioning exercise with them to get where you want. And I'll say that's kind of the biggest struggle with legal experts, is getting them to a point in which they feel comfortable enough with your international strategy that you can put their expertise forward, but also that you have sufficient confidence in the evidence that they are relying on, and the correctness, sufficiency of that evidence. Because in some instances you may not be savvy or very experienced at that specific jurisdiction, so you're relying a lot on what they are telling you. With more technical experts, the relationship seems to be a bit easier and more fluent. Some of them, if not most of them, are already acquainted with how an arbitration process works, so they know what to expect, they know what they need to do. For instance, in most of the mining cases, they know what you will ask them to prove, whether there's a resource, whether it's an estimate, whether how to read that information, which are the documents that will be pertinent to them, and the iteration is is much more similar to that with evaluation experts. They will be producing reports, they will be producing memorandums that you will then start questioning and kind of revalidating every once in a while. So I'll say those are kind of the biggest issues when interacting with experts.
And we've been speaking a lot about the first full submission, but Alexander, are there any considerations you take into account when you're writing the different types of briefs? Of course, each of them has a specific purpose. Are there any considerations? We have been speaking a lot from the claimant's point of view. When you're preparing the counter memorial or the rejoinder from the respondent's point of view, what are the key considerations you take?
From the respondent's point of view, so I think it's always very different when you're writing when you're writing secondhand. When you have a view. First, you have the calendar deadline is always a bit more surprising. You're receiving a request for arbitration. You've got 30 days to answer. Sometimes you can extend to 60 days, and so you've got a shorter calendar, so you've got to get things moving. Obviously, you probably received a notice of dispute before, so you've been able to start tackling and researching some of the issues, but you have an inherent disadvantage compared to a claimant, because you have less time to address some of the issues. When it comes to respondents' first memorial, I think this really largely depends on how much time you've negotiated in your procedural calendar. I think usually you have quite a strong leverage with the tribunal because you are respondent. I think that's even more so if you're a state. I think there's a great deference for states to have the time that they need to prepare, for the public employees working in government authorities to have the time to basically vindicate their rights and protect their interests. So it's a different I think it's going to be different in commercial cases. You're probably going to have less time, less leverage to negotiate a procedural calendar, especially since you're the claims are being poured against you, so usually you have to pay a certain amount of damages. So now when it comes to, I think, the second rounds of the question initially was the second rounds of memorial, but I think there's a junction when you come to a second round of memorial. It's a junction because a first round of the case, you have a first set. It's like a tennis game in a way, but it's a first set, and you've seen the strengths and you've seen some of the weaknesses, and hopefully a lot of it has been already identified. If you're a claimant, you now know if your clients have been lying to you, for instance, and that's I see I'm not the only one in that situation. And this happens with big corporations as well. It's not just you receive a brief and you're like, what are these documents? You send us all the emails, and you're like, oh, maybe no, I didn't send you all the emails. Oh, thank you. So this happens quite a bit, and you now know whether you need to be trying to figure out if there's a settlement option because your case isn't half as strong as it used to be, or whether you're actually very confident because you don't think that the evidence that's been put against you is actually that strong. You think, okay, I did have a truthful case. I do have a strong position. I can move forward. In between these two first and second memorial, there's also, I think, a second. There's that first issue about junction, whether you're strong in your position. There's also another thing that's happened is usually you're going to have document production, or you kind of had a document production. If that's the case, you're going to have to also analyze a lot of the documents that you've had and received, and whether they can be usefully put into your case for the second round of memorial. Because whether it's the second round of memorial for claimant or the second round of memorial for respondent, this is going to be your last round of written submission before the hearing. It's your last chance to make the strongest impression, to have that print in the tribunal's mind before they come and hear you out for 2 days, 3 days, 4 days, a week, whatever, how long that hearing is going to take place. And so I think you've got three concerns that you need to have is, first, have I tackled all the arguments of the opposing party? Am I bulletproof, at least in terms of counter arguments, or are there bullets flying in the air and, maybe an arbitrator is going to catch it and it's going to end up in deliberations and I'm going to lose the award on an argument that I never raised. I've literally witnessed this in a case. It was an argument raised as a one paragraph on a 200-page brief. It was a theory, a common law, English law theory of like 1650s, and it literally became the entire debate during the hearings and during post-hearing briefs, and we lost the case on that. So that wasn't very, very useful. But you need to make sure that you've addressed everything. Second point is, have I got all the evidence on record? Because there's a point at which the tribunal, however lenient it may be and however concerned it may be about due process, they will stop new evidence from being submitted. I mean, they have a calendar that the case needs to move forward. They will put a stop to that at some point. So you want to make sure in your second round of submission that all the evidence is now put on record. So that's your second big point. And I think the third point, but this is more again about providing a comprehensive and agreeable, digestible document, is to make sure that you're not repeating entirely what you've been saying in your first memorial. I had a former boss whose fondness was to say, please, he would basically carve out entire pages of the brief and put C, claimant's first respondent, and he would basically, he would want the tribunal, the second brief, to be something new, something, you have to bring something new to the table. You're not rehashing pages and pages of what's already been said in the first memorial. That's not useful. That's just adding paper. So I think these are the three kind of concerns I would have when I'm writing second rounds of submissions.
Thanks. And because we're already at 2:50, I'm gonna turn to Ricardo for the very last brief that sometimes happens, sometimes it doesn't happen. But after the hearing ends, the arbitrators will have received thousands of pages of pleadings, hundreds or thousands of exhibits. We'll have heard all the oral arguments from the parties. We'll have heard the witnesses, the experts, our post-hearing briefs necessary for.
Well, as you make it sound like they are not, and often we feel like they are certainly not. But it depends. It really depends. I think oral closing might be a good substitute for post-hearing briefs in certain circumstances. Imagine, for example, a bifurcated case where we have you're only arguing jurisdiction. Well, you're only arguing about the law in that case, and probably you can deal with your conclusions orally right at the hearing without need for a further brief. It might just not be necessary under those circumstances. But there are very complex cases, and often, investment cases are extremely complex. The record is very voluminous. There are a certain number of claims, different, could be large number of witnesses and experts, and it might be hard to put together an effective closing after a week of a hearing that is very intense and where everyone's working around the clock. I think post-hearing briefs give you the ability, they have one benefit, they give you the ability to reflect as to what transpired at the hearing, organize the information better, and prepare perhaps better some answers to questions that often the tribunal raises during the hearing, and you may want to address those questions after going back to your team with some time, thinking about what the best answer to that question is. If you do it overnight during the hearing, you might not have the chance to regroup and get the best answer that you can possibly get to the tribunal. And that, I think, also applies to the tribunal. If the tribunal, is forced to send questions to the parties right during the week of the hearing, they might not be given the chance to fully reflect on what happened at the hearing. It's perhaps better to give the tribunal a chance, especially in complex cases with voluminous record, large numbers of witnesses and experts, to think about the case after the hearing. Do perhaps a short deliberation and determine, okay, these are the key issues, these are the key questions that I need answers from the parties in order for me to draft them. And talking about drafting the award, I think post-hearing briefs are a great way and a great resource. If they are well written, they are a great resource because they can provide the tribunal with a roadmap for drafting the award. Ideally, if they're well written, they can have that effect. So I think they're useful. I've seen some tribunals asking for multiple rounds of post-hearing briefs. That can be a bit too much, but perhaps you do want to have a chance to reply to misrepresentations and correct certain things that your opponent has said. So it depends.
And as a follow-up, do you think post-hearing briefs should replace entirely your closing arguments? I have seen parties argue that closing arguments are not necessary or not useful, just go straight to the post-hearing briefs. What are your opinions?
I don't think so. I think closing arguments can be very effective because typically tribunals go to deliberation right after the hearing ends. And giving the tribunal a powerful concluding argument and summarizing what happened at the hearing and reminding the tribunal, with great, very sophisticated visuals, what is that beautiful quote from that witness that you got or from an expert that conceded that key point on the case. You do want to give them all of that ammunition for them to get into the deliberations room and start drafting the award. But I think, again, you may want also have the opportunity to be given some time to reflect and draft perhaps a focused post-hearing brief that only addresses certain specific questions that are given by the tribunal. But I welcome my colleagues' comments. That's only my opinion.
No, I think we can wrap with that and open the floor for questions, or I'm in the hands of. Good.
Try that again. Do you have any advice on peer review of your submissions, best practices?
If you could do it, it's invaluable, because what you have in a colleague who isn't close to the case is an audience who's very like the tribunal, or maybe very like the tribunal, so they can help you see tensions or areas where your argument isn't as clear as you thought it was because you've been living with it for 2 years. So yeah.
So at what stage is sort of the second half of that? Because I like doing it at the outline that you proposed. Maybe it's too late at the end, but
Yeah, you're right. I think about how we tend to do it is we tend to have peer review involved well before the final hearing, but sometimes closer to the written deadline. So, within the final couple weeks, as the document is coming together.
Enough time to change course if needed.
Enough time to fix it, ideally.
Yeah.
But it kind of all depends on availability and how constrained your timetable is and all of that. Yeah, but it's hugely valuable.
I'll throw out an idea that was something I always advocated for as counsel, and I care even more about it as arbitrator, but it seems to be a dirty word in this context. Page limits.
Oh, yeah.
Why can't we agree to them? Why don't we have them? How come they're not in our rules? And should we have them?
I think a case, you guys go ahead. If you
No,
want.
no, no, no.
But
Go
look, I think a case can be made for page limits, certainly in the later rounds of submissions or in post-hearing briefs. It's hard ex ante to agree a page limit unless it's a relatively generous one. If genuinely counsel and the tribunal don't necessarily yet have their arms around the size and shape of the case. But I think as the case develops and as the tribunal can help focus the parties on, look, this is what's really, occupying our minds, and this is where we really want you to focus your efforts. I think they're a useful tool kind of as the case goes on. But to impose ex ante, every case must fit within 100-page, courts do it, but we're not in court for a reason, right? So
It's hard. I've never had a case in which page limits have been not even agreed, but even proposed from the outset. Yes, for post-hearing briefs, all the post-hearing briefs that I've been involved in do have page limits, but not the main pleadings themselves. I've never seen it. I don't know if Ricardo or Alexander have had different experiences.
I have not seen them agreed for all of the submissions. I am completely in favor of it. I think
agree.
Lawyers
In favor.
have the ability to synthesize our arguments, and I think even the most complex case can be put. You can submit your arguments on the most complex cases in 100, 120 pages. I think you can do it. You have appendices that you can use to supplement your briefs.
See chronology, 200 pages of chronology.
No, but I mean, the idea is for the brief to do its work, and then if you need further detail, you have an appendix that can take care of that additional detail. But be careful. Only use them. You have to use them judiciously. But again, completely in favor. Never done it except for post-hearing briefs in practice.
Yeah. Certainly less is more. You should be trying to make your pleading as short as it possibly can be. And you should be reading it with an eye. Why is this in here? What work is this doing? Does this need to be here? If not, take it out. So yeah, shorter is definitely better. Shorter is harder. That's why we don't like them.
I think the microphone is.
Yeah, I think I got lucky. So you spoke quite a bit about catering to your audience when addressing the arbitrators and drafting the briefs. And I was just wondering where you have arbitrators from different legal backgrounds and so on in different legal cultures, how much of a role that plays in the manner in which you draft the brief.
I think it depends more on the type of case that you have rather than the style, right? So if you have a commercial case that is very sensitive in how you interpret a specific contractual provision, and you have one arbitrator with a civil law background and the other two with a common law background, and you're appended to the black letter of the contract, then you may want to cater the thing a bit more to the civil law arbitrator rather than the common law one. But I think it depends on the issues more than the case itself. You do pick your arbitrators first with that in mind, and it varies on whether it's investment or a commercial case.
I think in a perfect world, you try to serve something everybody wants to eat, right? So you try to frame your argument, if you can, in a way that works resonates across the piece. But if there's a real tension, if you're having to rely on expansive concepts of good faith, and you're going to have a couple people on the tribunal with their arms crossed going, what is this craziness? You just know you have to do more work to convince them that that's the right way they should be thinking about the case. But I mean, in a perfect world, you serve up something everybody's going to like to eat, whatever, or at least some part of it they'll like to eat.
I've had it's funny that you asked. We just finished a case where we had it was governed by English law. It was a corporate litigation, and it was governed by English law, and it had a provision in the shareholders agreement that mandated that the shareholder agreement be construed with good faith and applied in good faith, which is not a legal principle, from what I understand, under English law. Whereas, for example, in French law, you always have to act in good faith. You don't need to specify it by contract. You have to be in good faith. It doesn't seem to be the case with our English friends. But anyway, it was the case in this contract. And our tribunal, we had taken up, it was an English solicitor, but he was practicing in France. And the chairman was a Swedish law professor, so a very civil law background. And the English party had obviously selected a barrister. And it was very interesting because obviously they had a dissent. We ended up winning the case, so we're very happy. But the way we presented it and the way the feeling that we got with the tribunal is that they didn't really care that much about witness statements or that. The English counterparts presented the entire submission through exactly like you were saying, expert evidence, who were referring to some exhibits, but sometimes the documents existed, but they didn't refer to the document. They just stated what their views were or whatever that fact. And our feeling was that this was not going to fly at all with the chairwoman, and that's what happened. I mean, it came to a point where it was like, all these people seem to be biased to me. That was one of the comment, which was quite scary because we thought this could be a ground for annulment later on in terms of respect. So I think you have to cater. I think what Liz was saying is exactly true. You need to serve something that is eatable by everyone, but if it's not going to be eatable by everyone, make sure that it serves the majority of your interest. And that's where in a 3-panel arbitrator, the president is going to be. It's a key. I mean, perhaps had the president been a barrister, we would have lost this case. So I think it's extremely important to figure out the cultures and how they're going to want to eat what you have to serve, basically.
And I think we have time for one more question.
Okay, hello panelists. We are wondering whether or how are you making use of the AI technology when you're drafting this pleading or reading such enormous evidence? Yeah, thank you.
We do use it, only for purposes of reviewing documents and perhaps finding documents with very certain similarities, filtering some documents by date, by author, finding documents that have particular language, and we want to find other documents in a very voluminous record, or not even the record. Sometimes you get a ton of documents from your client, thousands of files, and certainly using AI tools allow you to identify what are the documents that mention this particular word that you're trying to find, as opposed to clicking, doing it manually. It saves a lot of costs for the parties, as for the clients. Certainly, the creative part of the work is to go and draft and use those documents and put them in a brief, and how you make them, how you squeeze the juice, as they like to say, from those documents. That's something that I don't think you can trust AI to do. I don't think it's ethical to trust AI to do it anyway. And
you don't use ChatGPT to draft your submission.
Absolutely not. And yeah, I think it's a hard sell for you, primarily to ethical rules. It's a hard sell in our profession.
Yeah, I've never used it other than for document review, translations, also like using DeepL to translate the document quickly or something. Okay. I have seen professors testing AI for legal sections, for instance, kind of with these set of facts, apply them to X standard, just as a theoretical, purely trying to show their students how it works. It's scary how accurate it can be sometimes. You do need to test it afterwards,
Right.
of course. And we may all be acquainted with a New York lawyer that used ChatGPT, and the chat ended up making up a case as a bad legal precedent that didn't exist. But I've seen how you can play around those, not for facts, because that may be trickier, but for legal. So once you've input the facts to the system and you say apply these legal rules, apply, I don't know, the Venezuelan legal code, then it's scary how
You don't need a
How good
tribunal
it is.
anymore. You just go through the software.
Right.
No, but there's also, for machine learning to operate, you need to have access to data. Right now, the machines have access, well, they have access to awards, but the frequency with which they have access to pleadings is different. If they had access to all the history of pleadings from all the best firms in the world, their capacity to draft a legal section on FET would be instantaneous. But they don't have access to that raw data now, because I don't think we submit our stuff to OpenAI. So, but I think that's the key thing. It's also they're not learning machines right now. They don't have the material to learn from the submissions, so it's more difficult for them to learn.
Yeah.
Okay, thank you.
Well, with that, I'm sorry, but we have to. I'm being ordered to finish. Thank you to everyone. Thank you everyone for being here.
Thank you.